all were concerned about Taxi, the movie, and whether or not, what would that generate? And this is to solve, that's response to that issue.
We're live.
Well, good morning. This is Senate Judiciary, a little bit late this morning due to floor action. And we are taking up, it's Tuesday, March 23rd, 2021. We're taking up H18 and act relating to sexual exploitation of children. But it's a fairly specific area of law that we will get into. It has to do with proposals to include simulated conduct within the definition of sexual conduct for the purposes of crimes involving sexual exploitation of children. And this is an issue that we took up last year, and we're continuing our work on that. On this issue, we passed legislation last year, but this is regarding a specific portion of that. So, Michelle, go ahead. If you could remind us a little bit of last year's bill as well as what's changed in this year's.
Sure. And is it okay if I share my screen to put the language?
Absolutely. Yep.
Okay. Senator Sears is correct. So last year you passed legislation updating Chapter 64, which is the title, which is the chapter on sexual exploitation of children, and that's in Title 13, and that focuses mostly on production and possession of child sexual exploitation materials. And so there were a number of little tweaks that you did that were upon the recommendation of the and you passed that. But there was one issue that there wasn't consensus on, and that was the issue of including simulated sexual conduct involving a child, and where does that, how could that fit in with this? And I believe Mr. Raymond had talked to you about certain scenarios that fell outside of the existing law that they couldn't prosecute, and why they needed the additional language for simulated. But it just, folks were in disagreement about what that language should look like. And so what you have now is a proposal that does incorporate simulated conduct into the definition. And there was quite a few hearings on it in the House. And so we had both the Attorney General's office, Defender General's office, and the state's attorneys as well in there discussing the language. I will cautiously say, they an agreement with regard to the language, but I'll let them speak for themselves. I think I'm not saying any necessarily supports it, but I think there was people got to a point of being comfortable with the language. And so let me put that up on the screen for you. Can everybody see that?
Yep.
Okay. So you're looking at section 1 in the definition section that would apply to the entire title. And remember, just a little refresher, when we're talking about a child, we're talking about someone who is under 16 years of age. And so you see subdivision 2 is the definition of sexual conduct. And then all the different things that constitute sexual conduct purposes of the chapter. And you'll see the addition on the top of page 2 of the new subdivision G. So any simulation of the conduct that's described above. So it may not actually be occurring, the simulation of that particular conduct of A through F. So there's a new subdivision 7 that's added here to further define simulation. So it means the explicit depiction of any conduct that's up above that we just took a look at, that one, it must involve a child as defined in current law. So we're talking about a full child, a live child. So we're not talking about that the conduct is what's simulated, not the child. And then subdivision 7.
So a child, it has to be a child, not a cartoon of a child.
Correct. Yep. So the second is under subdivision 7A, it has to create the appearance of such conduct that's listed up above. And it has to, on the third, it has to exhibit the naked genitals, buttocks, or breasts below the top of the areola. So you have to have an actual child. It has to create the appearance of the prohibited conduct, and it has to exhibit nudity as provided there. So you have to have all three things for it to fall under the definition of simulation for purposes of this chapter. You'll see in subdivision 7B, simulation does not include.
Wait a minute.
Okay.
It has to be both naked genitals, buttocks, or breasts, or is it any of the
Yes.
three?
It could be any of
Has to
them.
be, okay, because you just said something to the effect that it had to be all three, I thought. It could
No,
be
the,
any one of the three, or all.
Michelle meant the first three.
Oh, okay.
1, 2, and 3.
Right.
okay.
I meant that it has
Oh, okay.
an
I'm
actual
sorry.
child create the appearance of conduct, and there has to be nudity involved.
Right, okay, thank you.
So you'll see in subdivision 7B, simulation doesn't include paintings, drawings, or non-visual or written descriptions of sexual conduct. And subdivision 7C, as I mentioned earlier, simulation applies to the conduct, not to a simulated child. And then then it takes effect on July 1st. So I think probably if it works for you, is that rather than going into all the details about how this came about, is maybe if you hear from the witnesses and they can talk to you a little bit about their process and why they've gotten to this point here, and then I'll be here to answer any questions.
Yeah, I think, actually, I'm gonna jump right to Matthew Raymond. I think that's what I would prefer to do, who could talk about, as the director of the Internet Crimes Against Children's Task Force, just to make sure we have time to hear from him on the bill. And I might add that the same bill as introduced by the is S8, introduced by Senators Baruth, Sears, and Hooker, is the same as H18 as introduced. So, Mr. Raymond, thank you for being with us again.
Thank you for having me. And thank you and the committee for its work in passing the laws last year around this. And it's really been beneficial. Just to remind everybody, we're the Vermont Internet, I'm the commander of the Vermont Internet Crimes Against Children Task Force. And our primary purpose is to prevent the victimization or exploitation of children through the computers, technology, or the internet. We receive, just in cyber tips alone, which come from the National Center for Missing and Exploited Children, from electronic service providers that find child exploitation on their sites. We get between 300 and 400 complaints a year at this point. And the changes that were made last year really address helping to work through those cases more effectively and protect children in Vermont better.
How many cases did you just say? I missed that.
Between 300 and 400. That's just from electronic service providers. That's not counting, referrals we get from DCF, parents, schools, other police agencies. But that's just the cyber tips alone. And on top of doing the investigations, of course, we also do examinations of devices. And kind of the third leg of our stool is education, because obviously that's of utmost importance to us, is to educate children, parents, teachers, the general public about online safety to protect our children. So as far as the law changes, the last one that we had asked for was to incorporate simulated. Unfortunately, there's many images out there that get circulated that I think everybody, when they looked at it, would consider child sexual abuse material, but just don't fit under the current statutory language. And I apologize in advance to be graphic, but one such image, or we have many such of these images, but there's like 3 or 4-year-old clothed girls standing right in front of an adult male with an exposed erect penis. But the problem is, from the camera angle, you can't tell if there's actually contact between the penis and the mouth. There could be, but there could not be. And then that currently doesn't fit the definition. But the simulated language would draw that in as child sexual abuse material. And I would believe that everybody would agree that that is, an atrocious image and should be currently fit the definitions. So that's just one example. But why that I would ask that this get passed. I think the language that has been proposed this year is better and does take care of all the issues that were brought up last year about the concerns. I've seen the movie Taxi, I've seen Cuties and all the other ones, and this language would not apply to those movies. It wouldn't meet the statutory requirements that as laid out here. And I can answer any questions anybody has.
Yeah, unfortunately, I just lost my video. Try to bring it back. Talk about unstable broadband today. Can you, has the pandemic resulted in an increase in the behavior or no, in terms of the cases that you're seeing?
Yeah, so the first few months of the stay home, stay safe procedures, way back in like March or April of last year into May, we were seeing at first like a 1.5 and then a 2.5 times increase in the number of cyber tips we were getting those months. And usually those months are actually, there's kind of an ebb and flow to cyber tips. Usually those are down a little bit. I think it's because people are starting to get outside and maybe with computers some more. But with everybody in, we did see a sharp rise, and then how much was attributed after that, it's hard to say, because each year we're seeing just market increases each year in the cyber tips. When we first started doing cyber tips, I think it has increased like 219% the amount of cyber tips we get currently versus in 2015 when the agent's office took over stewardship of the ICAG. It just keeps going up each year, so it's hard to take off how much of that is pandemic related now and how much of that is just the natural occurrence of things that has been going on. And I apologize, anybody can hear that. That's my dog is snoring in the back.
That's fine. We're used to my dog taking over committee meetings when somebody's outside or he wants to go out or come back in. We don't mind. And pets are important to have around us, but sometimes they don't understand Zoom meetings. I don't have any other questions for Director Raymond, but I appreciate your joining us. Senator Nitka.
I was just wondering, where were we hung up last year? Why didn't it pass? Why didn't we include it?
Well, we passed a lot of the bill, but we didn't include this because of a concern that was particularly, speaking of dogs, that was particularly expressed by Marshall Paul regarding movies like Taxi and when those issues might have been simulated acts and would they be criminal or not. So we decided to wait until we looked at this issue again. I'm going to go take care of the dog, but maybe Detective Raymond can answer the question, or perhaps Marshall Paul would like to jump in.
Okay.
Yeah, there was language included that wasn't included last year, which includes exhibiting the nudity requirement. that wasn't in the bill last year. And that, I believe that language mirrors the New York language, which actually was where Taxi was filmed. And is predominant in actually a majority of states, I believe. So, but the attorneys can speak better about that aspect to it rather than I can. But I think that's where it was hung up last year, was not including that type of language.
I see. Marshall?
Sure, thank you. And good morning to the committee. That is where we were hung up last year, and I agree with Detective Raymond that at this point, the bill is not, we've addressed the two primary concerns that I had last year, which were the over-inclusiveness of the language, which, closely related was the potential unconstitutionality of that language. I still have concerns about the language in this bill, but they are not concerns with over-inclusiveness or constitutionality. It's simply that this definition of simulation is not consistent with what's done with what is, it doesn't reflect the language that's used in the case law. It's not clear, and it's just sort of a, it's an ugly way to write a definition, is to include the word that you're defining in the definition, which this one does. And my primary concern is with this, subsection 7C, which says simulation applies to conduct, not to a simulated child. Because that's where we get into that territory of using the word simulation in our definition or scope of the word simulation. We had in the House proposed some language that would have used the words that are used by the US Supreme Court and by other federal and state courts when they're considering this issue. They use the language actual child or real child. So they simply say that in order for a simulation to be prohibitable, it must essentially be the product of sexual exploitation of an actual or real child. That's the language that I proposed in the House. That language was consistent with, there had been testimony in the House from Professor Peter Teachout from Vermont Law School. He had proposed similar language or identified a similar concern. And that's also, that's, like I said, that's consistent with what's used in the case law. The Attorney General's office had an opposition to that language. I'll let them explain their opposition to that language, in part because, I think they are going to explain their opposition better than I am. And frankly, I don't quite understand their opposition. But that's why we wound up with the language we wound up with. Like I said, we do feel that this language is probably constitutional and not over-inclusive. We still don't support the language because it's our opinion that when you are, messing around with laws that are, and really not just messing around with, but really that, greatly expanding the scope of laws that are, carry very significant sentences. These are 5-year felonies, 10-year felonies, 15-year felonies, that it's really important to do the absolute best you can to keep the law tightly reflective of the boundaries that have been set by the US Supreme Court and, federal courts in our jurisdiction. And to me, that means using the language that they use, which is actual or real child, which in addition to being reflective of the actual case law, we feel is just simply clearer because that avoids this problem of using the word simulation to define the scope of the word simulation. So that's our answer. We're happy to provide the same language that we had provided in the past, though. Just one other thing I'd like to add is that we've been in communication with law professor, Professor Christina Hessek, who's really, among people who have written about the scope of the First Amendment with regard to child pornography, and actually about how to draft a child pornography law. She is sort of the preeminent scholar there. She's written the only articles that are really specifically about not just child pornography and the First Amendment, but about statutory drafting and how to draft the best child pornography law that covers everything that is covered by First Amendment case law, but does not cover the things that are not covered by First Amendment case law. She and I have been exchanging emails, and she has not yet given me her opinion of this language. We just most recently emailed back and forth last night, and she wanted to see more of the language from the chapter. So I sent her the whole chapter, and I haven't heard back yet. I'd assume that this is not going to be, assuming this won't be voted on today, and that there will be an opportunity for further testimony. I'd like the opportunity to come back, and perhaps even if Professor Hessek has anything particularly, if she looks at this and says, I think this is fine, I think this reflects actually some case law that's out there that, perhaps I didn't know about, and that, this is consistent with what's done in other states, then we would probably withdraw every objection that we have to this, because my objection to this is the fact that it doesn't reflect the case law and that it is inconsistent with what's done in other places around the country. And so, but if she tells me that I'm wrong about that, I'm happy to withdraw that objection. But if she tells us that there's problems in this that we hadn't identified, I'd like the opportunity for us to bring that information back to the committee, or perhaps even to bring Professor Hessek to testify. So that's what I would leave this as is, for now, we certainly think that this is constitutional and not over-inclusive. We just think that there's a better way to do this that's more accurate, more carefully ties to the case law that's out there, and to the extent that our reaching out to experts in the field leads us to a different conclusion over the next few days, we'd certainly like the opportunity to either withdraw our objections or bring the committee some more specific information about those objections.
Unmuted dog patrol. The good news for you is that we will not vote on the bill today. Won't even vote on the bill this week. So I suspect we'll come back to it early next week. And so yes, we would love to hear from, what's her name again? Hester?
Professor Carissa Hessek at,
Hessek.
I'm trying to remember the law school she's at. It's in
That's all
North
right.
Carolina.
If she's willing to testify, just let Peggy know, and
Absolutely.
so just let us know maybe by the end of the week when we put together our agenda for next week. So I'd be happy to hear from her, from you, and whatever, but we will take it up again next week sometime.
Certainly, Senator.
Okay. That's the good news. Anything else for Marshall? Any questions for Marshall? I'm sorry I missed part of your testimony. I was taking care of the dog. Okay. Next up is James Pepper from the Department of State's Attorneys and Sheriffs.
Good afternoon, or good morning. James Pepper,
morning.
Department of State's Attorneys and Sheriffs. So, the state's attorneys are very supportive of this bill. Certainly, there's a compelling interest in preventing children from participating in the production of sexual abuse material. We think that the addition of requiring nudity, actual nudity, takes this squarely into the realm of a crime and not in protected speech. Just the state's attorneys, just for the record, don't really prosecute these crimes. These are generally handled by Matt Raymond in the Attorney General's office, the Internet Crimes Against Children Task Force. So, but the mere fact, so they asked for this bill, and if they're asking for it, I think it really indicates that, they've had to decline prosecutions because of this simulation. I don't want to call it a loophole, but this gap in the law. And so the state's attorneys are very supportive of this language. They were supportive. They believe that the addition of nudity is what it was an improvement over last year's bill. So they believe the as introduced bill was constitutional, but certainly support this version that as passed by the House version as well. I don't have much more to add, but I think a lot of the kind of substance of the debate in the House was between the Attorney General's office and the Defender General.
All right. Well, thank you very much, and have a great day.
Thank you.
So we'll turn right to David Scher, and if we don't finish his testimony this morning, we will pick up with him next week. And we'll probably hear from you next week, depending upon how you and Marshall and the professor.
Thank you, Senator. For the record, David Scher with the Attorney General's office. And, I think a lot of the important substance has already been spoken about this morning on this bill. Commander Raymond, as he always does, did a good job of explaining the necessity for the bill and why we're asking for it. This bill has been the subject of a lot of discussion already. And as Marshall Paul pointed out, there is agreement on the constitutionality of this, but I think there remains a disagreement on precisely the right way to draft it. We support this language. We think that this is a good way to move forward that both addresses the issues of constitutionality while also addressing some of the concerns of our criminal division with respect to how exactly we create a definition that doesn't unintentionally make a higher barrier to prosecution than is constitutionally necessary or than we really intend to create. I think that, one of the key points of disagreement is that there's a preference on one side to precisely imitate some of the language in the federal constitutional case law, the U.S. Supreme Court case law in particular, by defining child for the purposes of a simulation as being an actual child and using that terminology. It's a position of our office that having that modifier to the term child could be interpreted by a Vermont court to mean something in addition to what the current definition of child is, which, it's our reading of the statute. The current definition of a child already means a real human being who is under 16 years old. And so adding that additional term could potentially lead a Vermont court to say, well, it already meant a real human being under 16. What does this actual mean on top of that? You've got to bring more facts to prove that. And, that's an area of disagreement in terms of statutory interpretation. But we support this language. It's our belief that this language is constitutional and it doesn't add that sort of wrinkle that we are worried about how a Vermont court might interpret that wrinkle. And, it's our read that a Vermont court may not necessarily look to the federal case law to say that that's what that must mean. They could do that. But they may just say, look, it's another word. We need to give that word meaning as we do in the course of statutory interpretation, because we read words not to be superfluous as a matter of standard statutory interpretation. And so we're going to require the state to bring forward another element of proof. So that was our concern with adding that. Obviously, again, that is an area of statutory interpretation where we weren't in 100% agreement, but we do support this language. We do believe it addresses the constitutional issues. And, we're happy to continue the discussion if we hear more from experts on the issue and see where that might take us. But that's where we are on it, and don't want to rehash the entirety of our prior discussions, but I hope that gives the committee a brief overview of where we've been and where we are. And again, happy to continue that discussion as needed.
How many prosecutions are there in Vermont?
Under these statutes?
Yearly under these statutes.
I'd actually ask Commander Raymond if he is still on the line. I don't have that number off the top of my head. He is more likely to.
Yeah, each year there's our arrests are between 40 and 50 persons.
Thank you. That's helpful. I understand the scale. Are any of those what we might term as sexting?
Well, no, not under what's commonly referred to as sexting. So when we have underage children sexting their age counterparts, we don't accept those cases for investigation at the ICAC because we have such a backlog of cases that involve, like 40-year-old men with under 8-year-old girls. So
During the
don't-
reason I asked is during our conversation last week about Manhattan, we heard of cases where a 15-year-old asking a 10-year-old or whatever to send pictures of their genitals. Curious if those.
Yeah, we have not had cases that involve juvenile on juvenile. We've assisted local jurisdictions with handling them when they couldn't figure some stuff out. But our priorities on adults that are abusing young children.
Are abusing, and generally the children are under 10.
Yeah, many times under 8. In fact, the two real disturbing trends that came out this year that I noticed, I review all the cases and assign them, are just a marked increase in toddler and infant abuse in Vermont, where there's sexually assaulting infants and toddlers and sharing the videos, and sextortion, which is when somebody convinces, it's usually an adult male convincing a young child to send sexually explicit images and then uses those that, first of all, they pretend to be their friend or offer them something. And then as soon as they get the first image, it changes, 180 degrees, and they start threatening them to do worse and worse things on videos to get more child sexual abuse material from these children. And many times when we have the victims in Vermont, the offenders are actually in another state, and then it works vice versa when there's victims in another state. And the offenders are here, they transfer those cases to us. We work with, there's 61 ICACs across the country, and we work in concert on those type of cases, and then typically prosecute those where the offender resides.
Senator White.
So I have to admit that this whole conversation is making me feel queasy. But, and I hope that you throw the book at the offenders here. But my question is, what happens to the children? How do we address the children?
Right. So the sooner the children are identified and the faster they receive services, the better the rest of their life will be. And that's pretty universally known. So we work actively to identify the children. When we identify the children that are here in Vermont, obviously we make a report to DCF. We get services involved right away. And whether that child needs to be removed from their surroundings or not, whether it was a family member or a familial like offender, obviously goes into all those decision-making points in those cases. And then nationally, when we have an offender here that has victimized somebody from afar, we rely on those states to get those services to those children. And then there's always those children we weren't able to identify, right, that we see in abuse images, because currently what used to be thought that there was a small amount of child pornography circulated among a small amount of offenders is this not true. We've done a better tracking, and we're up to like 4.5 million hash, and it might even be more than that now, hash values, and a hash value is a digital signature of an image or video that's unique to that image or video. So we know of at least 4.5 million images and videos. Now that doesn't mean 4.5 victims, because it can be multiple, unfortunately, multiple incidents per child. So then we worked all together and with NECMEC's CVIP, the Child Victim Identification Program, so that we pool information about all of our series. Like if this child's been seen before, then they're a recognized child. If they've been identified, they're an identified child. And if we've never seen this child before, it's a new unknown child. And then we work together, because if someone took 10 pictures of a child and you put all the background pieces together, we might be able to identify that child. But if I only have one of them, Georgia ICAC has one, Florida ICAC has one. So that's why we work with CVIP to pool all that stuff and then we'll go through the images or videos and try to identify something in there to identify the children, and then have the appropriate ICAC go make the rescue of that child.
Well, I really appreciate everybody's testimony this morning, and we'll pick up again